After the Revolutionary War, the people of America had their independence, and they had the Articles of Confederation. Many people felt that was all they needed. However, there were those who felt the Articles of Confederation weren't working. America needed a stronger central government, and so in 1787, a meeting was organized. The purpose was to improve the existing form of government. Today we call it the Constitutional Convention.
The Constitutional Convention was held in Philadelphia, Pennsylvania, where delegates from 12 of the 13 states were present. The state of Rhode Island refused to send a delegate because it was afraid of losing its state's rights. The delegates worked for 4 months behind closed doors of the State House to draft a new document known later as the Constitution. In Philadelphia, 55 delegates from 12 of the original 13 colonies met to begin writing the Constitution of the United States. These delegates were selected by their states. They were educated, patriotic, and experienced men between the ages of 40 and 81. Some of the men present were landowners, some lawyers or judges. All delegates held at least one public office. Some famous men were there. Ben Franklin was the oldest delegate. George Washington chaired the meeting. Others present included James Madison, George Mason, and Edmund Randolph. And some important men were not there, like Patrick Henry and Thomas Jefferson.
So began the Constitutional Convention on May 25, 1787. It was a long, hot summer for these writers of our Constitution. They wanted to make sure that the new nations and its citizens would be free and independent while at the same time protecting the people from a government that was too powerful from the rule of kings. They didn't want the wish of the people to be denied by any part of the government or by the power of any single leader. But they all knew that the government also must be stronger than the one-based Articles of Confederation. It would be a delicate balance to achieve. So the writers of our Constitution planned a very special kind of government and put their plan in writing.
George Washington had won the respect of his countrymen as commander of the Continental Army. Washington's fellow delegates elected him president of the Constitutional Convention because they held him in high esteem. As president of the Constitutional Convention, Washington's job was to keep the meetings orderly and effective. This was no small task, considering the many different points of view among the delegates. The delegates listened carefully when President Washington broke in to make a contribution.
Before the Constitutional Convention had begun, a Rules Committee decided how the process would work. No matter how many delegates a state sent, each state was given only one vote. If a state sent more than one delegate, all delegates had to come to an agreement about their state's one vote. Any delegate could voice an opinion. All proceedings would be kept secret until the Constitutional Convention presented a finished constitution.
The Constitution Convention met for 4 months. The 55 delegates were seldom all together. About 35 delegates were present during the process of writing the Constitution.
Delegates to the Constitutional Convention came from different backgrounds and held different political views. For example, they argued about how many representatives each state should be allowed. The larger states favored the Virginia plan. According to the Virginia plan, each state would have a different number of representatives according to the state's population. The smaller states favored the New Jersey plan. According to the New Jersey plan, each state would have a different number of representatives according to the state's population. A delegate from Connecticut, Roger Sherman, proposed a two-house legislature consisting of a Senate and a House of Representatives. The Senate would have an equal number of representatives from each state. This would satisfy the states with large populations. The House of Representatives would include one representative for each 30,000 individuals in the state. This pleased states with large populations. This two-house legislature plan worked for all states and became known as the Great Compromise. Once the debate ended, Governor Morris of New Jersey put the Constitution in its final form. He completed the task of handwriting 4,300 words in 2 days. The Constitution was signed by 39 of the 55 delegates on September 17, 1787. New Hampshire, the state with the smallest delegation, and Pennsylvania, the state with the largest delegation, shared this honor of having their delegates shine this honor of writing the Constitution.
The Continental Congress received the proposed Constitution on September 20th. It then voted to send the document to the state's legislature for ratification. The people who supported the new Constitution, the Federalists, began publishing articles supporting the ratification. They believed the checks and balances system would allow a stronger central government to preserve the states' rights. Their 85 essays became known as the Federalist Papers.
Originally, some people did not want to ratify the Constitution because it did not have a Bill of Rights, which is an individual list of every citizen's rights. 12 amendments written by James Madison were presented to the states for final approval. 10 of those changes were agreed to the states and were added to the Constitution. These 10 amendments were called the Bill of Rights. Some of these rights might sound familiar to you. The right of free speech, the right to practice your own religion, and the right to be silent if you are arrested.
Once ratified, the Constitution set the basis for the government we have today. Powers are divided between the federal or national government and the 50 states. The Founding Fathers knew they had to leave enough powers with the states when they were writing the Constitution. If they didn't, they knew the state legislators would never ratify the Constitution. All states were granted the right to control certain things within their borders. They could do so as long as they did not interfere with the rights of other states or the nation. Delegates of the Constitutional Convention also wanted to divide the power within the federal government. They did not want these powers to be controlled by just one man or one group. The delegates were afraid that if a small group received too much power, the United States would wind up under the rule of another dictator or tyrant. To avoid the risk of dictatorship or tyranny, the group divided the new power into branches: the executive branch, the legislative branch, and the judicial branch. These three branches are not independent of one another because the Constitution set up a system of checks and balances to help ensure that no one branch became too powerful. Each branch has powers that it can use to check and balance the operation and power of the other two branches. The judicial branch is headed by the Supreme Court. Its powers include interpreting the Constitution, reviewing laws, and deciding cases involving states' rights. Its checks over the executive branch include life appointments free from controls and judicial review of executive action. The judicial branch has a single powerful check over the legislative branch. The courts can judge legislative acts to be unconstitutional. The executive branch is headed by the president. The president carries out federal laws and recommends new ones, directs national defense and foreign policy, and performs ceremonial duties. As checks over the legislative branch, the president has veto power, the ability to call special sessions on Congress, and opportunities to recommend legislation and appeal to the people. The president generally has an easier job when the House and Senate majorities are of the same party as the president. The president's checks over the judicial branch includes appointing Supreme Court justices and other federal judges.
The legislative branch is headed by Congress, which includes the House of Representatives and the Senate. The main task of these two bodies is to make the laws. Making laws is an involved process, which my friend will tell you about shortly. The legislature has powers to check on the executive branch. These include its ability to override presidential vetoes with a 2/3 vote, its control over the purse strings, passing laws, the House's power to originate spending bills, and the Senate's power to impeach officials and approve treaties. The legislative branch can check the powers of the judicial branch by creating lower courts, removing judges by impeachment, and by appointing judges.
How does a bill become a law? A bill begins as an idea which is then researched. Only a member of Congress can introduce a bill. By the time it is introduced, it has a number of legislators. The bill is directed to a committee which discusses it and determines whether or not it should be brought to the floor. The committee vote is reported, and if it passes, the bill proceeds to the floor where it is debated. Congressmen and women explain why they agree or disagree with the bill. Changes are recommended, and when those changes are made, the bill is ready to be voted on. Voting is done electronically. If a majority vote yes, the bill passes. It is certified and sent to the other body to be voted on. If it passes again, it is ready to go to the president for his action. The president may 1. Sign and pass the bill, making it a law. 2. Refuse to sign the bill, thus vetoing it. Or 3. Do nothing, which is called a pocket veto. If a bill has passes in both the House of Representatives and the Senate and has been approved by the president, or if the presidential veto has been overridden, the bill becomes a law and is enforced by the government. The American system of checks and balances has worked well over the course of America's history. At times, huge clashes have occurred, but these occasions are rare. The system was meant to keep the three branches in balance. Overall, the three branches have achieved a workable balance with no one branch holding all the governmental power.
When the Constitution was written, its creation was not perfect. They wanted to make sure
it wasn't too hard
that it wasn't too hard to
or too easy
to make changes. They wanted to make sure that
changes could be made.
changes could be made. They wanted to make sure that
The process allowed for changes.
the process allowed changes.
Currently, there are 27 amendments. This includes the first 10 amendments called the Bill of Rights. The last change to the Constitution was made in 1992. The 27th Amendment is actually